Please be seated. We're going to call the cases in the order they appear on today's calendar. I'd like to welcome particularly the FSU Business School students here today out in the audience. And at the break after the first case, we're going to ask the lawyers for the parties to join us, if you like, in the Commons for coffee. We'll call the first case, McDonnell.
May it please the Court. My name is Michael Ufferman, and I represent the appellants, Christopher and Brian McDonnell. I'd like to reserve 5 minutes of my time for rebuttal. The sole issue in this case is whether the trial court erred by denying the appellant's motion to suppress. There was no search warrant in this case, but the state took the position that the search was valid because Christopher McDonnell consented to the search of his residence. As I've explained in my briefs, I submit that the circumstances of this case demonstrate that any consent was either coerced or was involuntary because it was given in response to a show of authority from law enforcement officials. I also submit that Investigator Mathis's advisement that he would return with a search warrant vitiated Christopher McDonnell's subsequent consent. I've relied upon 6 factors in the briefs that demonstrate that consent was invalid or involuntary. One, and probably most importantly, Christopher McDonnell was not free to leave the front of his residence, where he was forced to stand wearing only a bath towel. 2, the encounter began in the early morning hours, somewhere between 4 and 4:30 a.m. 3, Christopher McDonnell remained outside his residence for approximately 2 hours wearing only that bath towel. 4, there were at least 6 different law enforcement officers present at the residence. 5, during the time that Christopher McDonnell was forced to remain outside the residence, he was confronted with the officers asserting that they would find evidence of the crime inside the residence. And then finally, the officers repeated their request for permission to search the residence. When they initially approached him, he did not give consent. And then after the 2 hours of him being forced to remain outside wearing only a bath towel, they approached him again said, will you give us consent? And it was only at that point that he consented.
Wouldn't the police have had probable cause to place him under arrest at that point in time?
Place him under arrest?
Yes.
No. And I think Investigator Mathis was asked that question during the suppression hearing.
But what he thinks really isn't dispositive,
true,
is it?
But I think it's relevant. And, of course, he said, I did not have a basis to detain Christopher McDonnell. And I think perhaps the standard between probable cause to arrest and probable cause to search are similar. I think they're maybe the same. And in order to obtain a search warrant, and you're asking about arrest, I guess I'm going to address
Well, I mean, it was later that they confessed at the police station, correct?
Correct.
So even if the search were suppressed, why did the confessions have to be suppressed?
Because I think they confessed after being confronted with the evidence that was obtained during the illegal search. And the Shingles case that I've cited says that would be the fruit of poisonous tree.
I mean, they had the videotape of the truck, which would have come in, the ID witness who said, that looks like the McDonnell boys. And I mean, they had quite a bit of compelling evidence, didn't they?
Well, let's back up. We may be commingling some of the evidence. And you may be asking a couple different questions. I want to make sure I address the right question. In terms of is the issue, the motion to suppress, dispositive, I think all the parties have agreed that it is. And if you're asking that perhaps maybe they would have been able to go forward even without the evidence from the search or even without the statements, I submit that they would not have been able to do so. So, of course, I would respond to a question regarding whether or not the motion to suppress was dispositive that way. And if you have any further questions, I'll address that. But if you're asking about inevitable discovery, which I think the state recently filed a notice of supplemental authority, and in their notice they've cited a number of cases that deal with inevitable discovery. First I would note, although the trial court apparently relied upon inevitable discovery, the state in their answer brief didn't say anything about inevitable discovery. They seemingly abandoned that issue, and now they're raising it for the first time in this notice of supplemental authority. If it's something that the court is considering, I would ask the opportunity to provide supplemental briefing on that issue, because the appellants haven't been able to argue that issue in the briefs. But nevertheless, I think the question for inevitable discovery goes to whether or not the officers on the morning in question would have been able to obtain a search warrant. Did they have probable cause for a judge or a magistrate to issue a search warrant? So we have to look at the facts that they had. There apparently had been the theft of an ATM sometime in the late evening hours or early morning hours. And there was a lot, and then the theft occurred at a hotel. And Mr. McDonnell, Christopher McDonnell, was an employee at that hotel. So a loss prevention officer stated that he saw a truck, and he saw the tag or the license plate from that truck, and he said that that truck and I think I want to quote him. He said, possibly used in the crime. Well, possibly used, we don't know what that means. Does it mean that the truck was seen sometime around, or on the premises sometime around the time that the ATM was taken? Well, I submit that that wouldn't be unusual. If Mr. McDonnell was an employee at the hotel, it wouldn't be unlikely for him to be driving a truck that was linked to his father on the hotel premises. So, and the other thing is, this loss prevention officer wasn't identified by name in the record. All we know is that a loss prevention officer saw a truck that said that the truck was possibly used as part of the ATM crime. Because they didn't identify him, I submit it's more akin to an anonymous tip. So what do they do once they get this tip? They go to the appellant's father's house, and because they're able to link the license plate number to the father, but they see the truck when they get there, and they examine the truck. Investigator Mathis says that I examined the truck, and there's nothing based on my examination of that truck that tells me that this truck was involved in a crime. But they still go ahead and question the father, and the father said that my son Eric used the truck that day, and he took some yard debris to the appellant's residence. So based on that, the officers then go to the appellant's residence. They confront Christopher McDonnell at 4:30 in the morning. He's wearing only a bath towel. They ask for consent. He doesn't give it. I submit that those facts right there would not be enough for probable cause. So the other fact that they do have, and this is what you were alluding to, Judge, they apparently had a videotape of a unrelated burglary. It's not the theft of the ATM. It's some previous crime that occurred at the hotel. And the police took this burglary videotape and got a picture of it, and then they presented the picture to 4 employees of the hotel. But only one of the 4 employees was able to say, I believe that the men depicted in that picture are the appellants. The other 3, who also were familiar with the appellants, said no, that they didn't believe that the men depicted in the picture were the appellants. So you have 1 out of 4 making an identification, or 3 out of 4 not making an identification, plus some information from someone who's not identified who says that a truck was possibly used in a crime, plus they're able to examine the truck and see that there's no evidence that the truck was used in a crime, and the truck isn't at the appellant's residence.
Well, I mean, what evidence would there be? I mean, the ATM's still sitting in the back of the truck, but apart
Sure.
from that, what would there be?
Sure, I think something more than the truck was possibly used. We need to know some more of those details. If the judge or the magistrate is presented with that information at 6 o'clock in the morning, he's going to say, what does this mean, Investigator Mathis, possibly used? You need to be a little more specific. And, of course, the state had the burden at this motion to suppress hearing to establish if their theory was going to be inevitable discovery. They had to put on evidence to prove that, and they didn't put on evidence. All they simply said was the truck was possibly used. So there's not enough. They didn't name who the loss prevention officer is. So
That's not really akin to an anonymous tip, though, is it? I mean, the defense wouldn't be totally stymied in discovering if there was some kind of bias or motivation for this witness to provide information that would be interesting to a jury. I mean, the loss prevention officer at the hotel at the time the police officers went there, I mean, you practically named him. I mean, it's just a small step to figure out exactly who it would be, right?
But they didn't. I mean, they need to go further, so it is possible for the magistrate or the judge to know that they have consulted with this individual who they know his name, they can follow up with him, and he's made this identification. And again, they need to go further. What does he mean possibly used in the crime? Does he mean that the truck was simply in the vicinity of the hotel at the time the ATM was taken? Or does he mean that he saw someone load an ATM into that particular truck? Of course, that would be far different. And I submit in that situation, maybe we are getting closer to probable cause. But from what we have in this record, possibly used, that doesn't meet the standard of the state must demonstrate that there is a fair probability that the evidence will be found in the area to be searched. Again, based on all of these factors, the state simply hasn't met its burden of proof that this evidence would have inevitably been discovered. And again, we've already addressed the idea that the officer or Investigator Mathis did not believe that he could arrest.
Well, does inevitable discovery really apply where, I mean, couldn't we frequently, wouldn't that eat up the search warrant requirement?
If we went on the
If we say that the police could have gotten a search warrant, they didn't bother to get a search warrant, but they could have, so therefore we're going to allow it under inevitable discovery.
No, I think that's, you said that's the inevitable discovery doctrine. If
But,
this
I mean,
court
but
believes...
not in the case of failing to get a search warrant, is it? I mean, is that included within the scope of the...
I'm not sure I'm following your
I
question.
mean, in other words, if the inevitable discovery is, Judge, if we had bothered to get a warrant, it was really a pain in the neck. We had to type. It was late at night. We didn't feel like doing it. But we could have. So therefore, we don't have to get a warrant because we could have gotten a warrant.
I agree. They have to establish that they could have. That's the key.
Well, no. I mean, I don't even think that. I don't think inevitable discovery applies when the police inevitable discovery is we could have gotten a warrant. I mean, it's not like through independent means we would have come across the evidence anyway. This is not independent means. Our investigation would have led us there anyway. I mean, we didn't get a warrant, and we're excused from getting a warrant because we could have gotten a warrant.
But again,
You would
I
never
think
have
what
to
you're
get a
saying,
warrant.
and I
I
want to
mean,
make sure.
if that were the rule, then police would never have to get a warrant as long as they had probable cause.
I think, unfortunately, that's the rule. The Nix case from the United States Supreme Court said that.
No.
If the state could inevitably get the...
That's fine. I don't think it said that, but that's okay.
But again, the key to the inevitable discovery doctrine is they have to prove that they could have gotten the warrant. And in this case, I submit, and again, it couldn't be, I mean, what other time would they come back? And they would have to demonstrate that maybe there was additional evidence that they were aware of, and they would have come back and relied upon that evidence to get the warrant. All we know are these two factors, the loss prevention officer saying the truck was possibly used, plus this videotape of an unrelated crime. And I submit that those two factors don't give the police enough to get a warrant. That doesn't amount to probable cause. I know I'm in my rebuttal time, but I do want to address one other issue quickly. The other thing is we need to ask what happened to the affidavit. We know that Investigator Mathis leaves the residence at somewhere around 4:30 in the morning, and he has about 2 hours that he says he's filling out an affidavit in support of the search warrant. In that 2-hour time period, he doesn't submit the affidavit and the search warrant application to a judge or a magistrate, and then he said he's called back because now Christopher McDonnell has given consent. So he comes back to the house, he says he has the affidavit in his possession, but then he acknowledges that he later destroyed the affidavit. He has taken away your only opportunity to review what would have been in that affidavit. We'd be able to see what facts he would be relying upon to establish probable cause, but he destroyed it. And that's not the only document that was destroyed in this case. There was also supposedly a consent to search the residence form that Christopher McDonnell signed. But again, when the officers were questioned about that consent to search form at the suppression hearing, the officers acknowledged that it's now either lost or destroyed. So another issue that I think does relate to the inevitable discovery doctrine is bad faith. And there's some courts in this country that have said that if the officers act in bad faith, the state can't rely on the inevitable discovery doctrine. I'd like to reserve the rest of my time for rebuttal. Thank you.
May it please the Court. My name is Heather Ross, and I represent the state of Florida. Here, the record does support the state's contention that Christopher McDonnell's consent was voluntary. One, the appellant, when he was initially confronted at the door by Investigator Mathis, he knew that he could refuse consent for him to search. He knew that they could not come in without a search warrant, and that is a very important factor here, that he knew his rights and exercised them.
Yeah, but then didn't they stand him out in his underwear for a few hours?
Yes, Your Honor, it is clear from the record that they did do that. I do submit that other than Christopher McDonnell's testimony that he asked Deputy Strobel to go into the house after Investigator Mathis left, is the only testimony that we have that he was not allowed to go back into the residence. There is no other testimony from Sergeant Walker, who initially got the consent from him, that he never asked him to go back into the residence. He never asked to be able to put clothes on, and other than the uncontradicted testimony. He wouldn't have to ask to put
clothes on, would he? For
well,
that
Your
to be
Honor,
a factor.
he was in a towel, so I would have thought he would have asked for some clothes. Probably.
Can't we assume that he would want to put clothes on before he stands out on his porch for 2 hours with a bunch of police officers around, or is that not a safe assumption?
Well, you never know how comfortable he felt. I mean, he felt comfortable enough to come to the door at 4:30 in the morning in a towel. He definitely didn't ask. There's no other testimony than that one time that he tried to go back into the residence. The officers did not physically hover over him. All the testimony that we have from the record states that they stood out in the front yard. The only officer that really approached him and either stood there with him on the porch was Sergeant Walker at that point. And so I guess he just wanted to stay out there in the towel. We don't really know what his thought process was on that. Maybe he wasn't modest and that he didn't mind being out there in a towel with a bunch of men.
Are you arguing inevitable discovery?
Yes, sir. I was going to bring up that.
Tell us about that. Why is there inevitable discovery here?
Well, there is testimony from Investigator Mathis that he was in the process of getting a search warrant. When he originally went to the premises and spoke to Christopher McDonnell, he did not try to coerce him. He simply asked for consent. He was refused. He then said, okay, well, we'll go get a search warrant. He goes and leaves the property, and from what we can tell from the record, he leaves the property, and he's been gone for an hour and a half to 2 hours.
What about this? I mean, what factor is critical in that inevitable discovery? I mean, for instance, if the same facts were present, but the officer never left the scene, but instead his testimony at the hearing was, I could have left, I could have been gone for 2 hours, and then I could have come back. And I could have drafted up an affidavit that I later destroyed. I didn't do any of that, but I could have, Judge. Would that be inevitable discovery with the same facts, it's just that the officer doesn't leave? I mean, is it necessary that the officer leave the scene to support your inevitable discovery argument?
Yes, sir, I believe it does. That the possibility
Does he have to leave the scene for an hour and a half? I mean, how do we judge? I mean, why is leaving the scene the critical factor?
Because he went to the sheriff's office or wherever he went to fill out the affidavit and the application for the search warrant. It's 4 o'clock in the morning. He's going to have to go find a judge and wake a judge up. He's not going to be able to call a judge and say, Your Honor, will you please come down here? He's going to have to go to them. And at that point, if he is willing to go that far to get and bring it down all the way to that line, it's completely different.
I wonder if he had a computer in his car and he was sitting in his car typing up the affidavit and the search warrant, and then there was a consent or a disputed consent. Does he have to leave the scene in order for there to be inevitable discovery?
Your Honor, I do not really, well, I understand your question. I do not think that is the pertinent part of that he was there on the scene doing the affidavit and the
No, I just think that your argument kind of comes down to we could have got a warrant, so we don't really have to get a warrant because we could have got a warrant.
Yes, Your Honor, but at that point, he was in the process, and we do not want to deter our law enforcement officers from continuing in their legal duties.
So I'm just wondering how far down that road they have to go in order to have done enough not to be deterred from doing it the way they're supposed to do it. I mean, are you conceding that this was non-consensual search?
Oh, no, sir.
You're saying it was consensual, but even if we wanted to somehow engage in a flight of fancy and find that it wasn't consensual, it was inevitable.
Yes, sir. That's what I'm arguing now.
What facts did the trial judge find that would make, that we could rely on to make this a consensual search? Besides conclusions, what facts?
The facts. The trial court he found an implicit consent. He did not, in his oral order, he did not specifically state to anything other than that he believed that there was a consent. Part of
no
that
specific
consent,
facts that the trial judge found that we could use in our evaluation?
No specific facts were in his order. Now, he did state the facts that Chris McDonnell, the tape, they had the tape of the ATM theft. They had a tape of the armed burglary. They had the tag number from the truck that was seen stealing the ATM. The loss prevention officer that told him that he saw 2 or 3 white men in the truck. He had, one of the employees said, oh, well, this picture looks like the McDonnell brothers. The truck came back to James McDonald. All of these factors altogether come down to where the judge said, I believe that there was probable cause. There was probable cause for a search warrant. And but for if this court finds that the consent wasn't voluntary, then the trial court, a reasonable court, found that there was probable cause for a search warrant, and therefore inevitable discovery would apply here, because they would have gotten a search warrant, but for Investigator Higgins calling him, telling him that we had a consent.
Why didn't the officer save the affidavit that he'd spent 2 hours typing?
Your Honor, that's not real clear in the record why he destroyed it.
Does that matter? I mean, the appellant's complaining there's something we are not able to review. Does that matter that it was destroyed or not?
No, Your Honor, because the search warrant wasn't actually procured at that time. Also, with this, to the issue of the voluntariness of the consent, at the end of his testimony, when he was asked by his own counsel, he said, "Did you feel that you had a choice about whether or not to consent to the search?" And the appellant said on the record, "I could have said no and waited for the search warrant, but I was trying to cooperate."
Isn't that the case, though, in Bumpers? Doesn't that almost make the argument that Bumpers is applicable? In other words, he thought that they had the warrant anyway, so he could either get off the porch at 4 o'clock in the morning with the towel, or he could continue to stand there for who knows how long it's going to take the officer to finish his typing and find the judge, and so he might as well get it over with.
Well, yes, Your Honor, I could see where you would think the Bumpers would apply here. Here it just shows the clearness of his mind that he wasn't being coerced, he wasn't being threatened, he just was going to cooperate with the police. Sergeant Walker, during the search of the property after he had consented and they come in, Sergeant Walker sat with him and told him that he could withdraw his consent at any time. That the police never actually told the appellants that they had a search warrant, that they were just applying for one.
Getting back to inevitable discovery, if you don't mind, I just want to recite those facts that you think are most favorable to that trial court's ruling regarding probable cause in a succinct fashion. My understanding is the ATM is taken. There is a photograph of the truck leaving the Marriott property that shows the tag number, right?
Correct.
From the ATM theft.
Yes.
That tag number belongs to the appellant's father.
Yes,
that
sir.
Tag is registered. He voluntarily tells the police
that his son,
Eric, took that truck to the defendant's home, the appellant's home, because they were taking debris to the Marriott.
Yes, sir. That's correct.
Which is where the theft occurred.
Yes, sir.
So essentially, and then what is the evidence again regarding the showing the photograph to the Marriott employees?
Showing the photograph to the Marriott employees.
From the other burglary?
On the other burglary. They had taken the videotape to a special store for them to take still pictures from that videotape to be able to show to the employees at the Marriott. One
out of 4 identify the appellants.
Correct, Your Honor.
And all that occurred before they go to the house at 4:30 in the morning, right?
That is correct, Your Honor.
So you have one witness who says that looks like the appellants. You have a tag number to the car that's registered to their father. Their father provides information that links them to the scene of the crime. And that's what you have. And a photo of that tag taken at the time of the theft.
Yes, Your Honor.
So it's your argument that that evidence shows that it was more likely than not that the appellants were the perpetrators.
Yes, Your Honor. And that is what the trial court actually found in this case. It found that there was sufficient probable cause, that they would have gotten a warrant, and then he said that they had consent, the statements, and the evidence shouldn't be suppressed.
Does the inevitable discovery doctrine extend to the confessions made by the defendant?
Yes, Your Honor, I do believe so, because I would think that anything after the discovery of the evidence would be fruit of the poisonous tree. So they would not have been there if they had not found the evidence. They would not have been in the interrogation room if they had not found the evidence.
So you don't think the police had probable cause for arrest? Based on just what Judge Thomas outlined, you don't believe the police had probable cause for arrest?
It is not clear from the record. Well, it's clear from the record that Investigator Mathis did not believe that they had probable cause to arrest them.
But do we even care whether or not what he believes about that? I mean, it's not relevant, right? I mean, probable cause is not subjective to Officer Mathis. I mean, it's an objective determination, correct?
Correct, Your Honor.
So if those facts give rise to probable cause for arrest, it doesn't really matter what Investigator Mathis said at the suppression hearing.
Correct.
They would have been able to arrest. And if they're able to arrest, they would have been able to question. And if they're able to question, they could waive their Miranda rights, correct?
Correct. Which, in fact, they did waive their Miranda rights, signed Miranda forms, and continued to talk to the investigators. Inevitable discovery is a very important part of this analysis, and I mean, they had the two defendants working there. They had the video, the ATM theft. They had the armed burglary. They had the tag number. They had the loss prevention officer saying that there are 2 or 3 white men in the truck. The truck came back to James McDonnell. The dad told Investigator Mathis that his sons had his truck. The dad gave them the address. They went, and they didn't get consent until later on. So the state respectfully asks this court to affirm the lower court's judgment and sentence. Thank you.
Thank you, Counsel. Rebuttal?
May it please the court. If I could just quickly respond to some of the facts, Judge Thomas, I'm not sure. My view of the facts may be a little different. I don't think there was a photograph of this truck used on the night of the alleged ATM theft. I think the photograph relates to an armed burglary that happened on a previous date. The way we know about the truck being used is this loss prevention officer or loss control officer from the hotel who's not identified in the record, who said that I got a tag number of the truck that was, quote, possibly used in the theft of the ATM. And then we also, the appellant's father didn't say that they were taking debris from the appellant's father's house to the site of the hotel. He said they were taking yard debris to the appellant's residence. So the appellant's father didn't concede that the truck was being used or taken to the site of the...
He said they were taking debris from the Marriott to the appellant's home, or vice versa? It doesn't really matter.
He may have said that. I thought they was taking it to the appellant's home, but he may have said...
But he ties in the Marriott.
I believe so. And then again, of course, Christopher McDonnell works there. But the only thing linking that truck to the alleged theft of the ATM is this statement from someone who's not identified, but apparently it's an officer at the hotel, that said it was possibly used. We don't know what that means. We don't know if it means that someone saw someone loading an ATM into that truck, or if someone just simply saw the truck at the hotel at the time that the ATM was allegedly taken. There's just not enough information based on the ATM theft to establish probable cause. And I think when you look at the burglary, the separate incident where the employees were shown the photographs, yes, 1 made an identification. More importantly, 3 did not. And 3 did not, who are aware, worked at the hotel, were aware of what Christopher McDonnell looked like, and none of those people said that this looks like him. I think a magistrate or a judge being presented with that information is certainly going to say this doesn't amount to a fair probability that he was involved in this crime, because only 1 of the 4 people could even link him to it, meaning 3 did not. So I think that's very important. I think.
Why do you think the trial court found there was probable cause to issue a search warrant?
Well, I think it's. Well, I mean, he's relying upon these same facts. Of course, this court needs to review that. I think it is clear that the trial court didn't find that this was consensual. His reasoning is contained on 123 and 124 of the suppression hearing transcript, and he simply basically says it's inevitable discovery, and he thinks that the search warrant would have issued. I submit that he may have been confusing some of these facts. He may have been confusing the picture and the previous burglary with the current offense, but when you look at them for what they are, the statement that it was possibly used, it's a separate burglary, only 1 of 4 makes the identification. I submit that's simply not enough. Because again, we're also, are you looking for evidence that the burglary may have been committed, and there's evidence from the burglary in the appellant's residence? Are you looking for evidence of the ATM machine? I think on this particular morning, they're looking for that ATM machine. So the picture in the previous burglary may not be as relevant as who can link the appellant and being in that truck at the time of the ATM and being involved in the theft of the ATM. And again, they've observed that truck at the appellant's father's house, and they didn't see anything in their observation that would demonstrate that that truck had been used in a crime. There's simply not enough for a court to find that there was probable cause to issue the search warrant. Again, I would rely upon bumper, and Judge, you've already hit on this. If the courts have said, in particular the Barker case from Indiana, that telling someone I already have a warrant, will you give me consent, is no different from telling someone that if you don't give me consent, I'm going to go get a warrant. And that's what was said here. Investigator Mathis said, when Christopher McDonnell said, no, I'm not going to give you consent, he said, well, I'll go get a warrant then. And then 2 hours later, in his mind, he's thinking, they're going to get the warrant, I might as well consent. I'm sitting here in my bath towel. I'd ask the reverse. Thank you.
Thank you, counsel. We'll recess now. We again invite counsel to join us in